Hey everybody, it's Harley with Thoughtful Talk. Today we're gonna dive into the court hearing that they had yesterday for the Charlie Kirk assassin, Tyler Robinson. Looks like defense is gearing up against the media, and there might have been a violation of a court order. Let's get into it. Hey, welcome back everybody. If you have not yet, hit that like button, subscribe to the channel, make sure you guys hit that little bell notification so you get notifications when we post, when we upload new content, and when we in the future go live. Looks like today in the Charlie Kirk case, there might have been a violation of the standing decorum order that the judge had ordered a while back in the first appearance of Tyler Robinson. It looks like they are allowing the media to be in the courtroom. However, there are some rules, and looks like some of those rules might have been broken. Let's look at some video.
We're going back on the record in case 251-403-576, State of Utah versus Tyler James Robinson. I note the presence of counsel that previously entered their appearances. We have come out of the closed session and concluded that business. However, the court became aware of an event that happened before. And my understanding was during the open portion of this hearing earlier that there was a violation of the standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel, and then I will make a ruling concerning that shortly thereafter.
So what we got to hear there is the judge saying that there was possibly some violations of that order that he made, and he's calling up counsel to hear those claims and for them to basically proclaim their case. Let's hear what they had to say.
Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice, if the judge makes particular findings and that the specific circumstances warrant it. It is our position, the defense position, that there has been a violation of the decorum order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order, and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my client's right to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible. It is also our understanding that potentially some audio from counsel table was heard. We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at counsel's desk. That's entirely inappropriate. And I think everybody in this room will agree that's entirely inappropriate. So we are asking for some remedial measures here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Visser.
So we had gotten to hear from both the defense attorneys, the prosecuting attorneys, and the media attorneys. Sounds like the media attorneys obviously acknowledging that there was some issues and ongoing. So we'll see how they handle this.
Problem.
Thank you. I appreciate all parties weighing in on this important matter. And I find that there was a violation of the standing decorum order that was in effect as of October 30th, 2025, based off what's been proffered, as well as the AMC order signed by the court. As previously stated by Ms. Visser, the court does have discretion in determining whether to terminate the broadcast of these proceedings. And again, if there are specific circumstances warrant such action, that the court would need to make findings in order to do so. I find that excluding the cameras from the courtroom would be disproportionate for this hearing. I find that making it very clear, first, that the transmission cannot begin until court is in session and must end as the court ends the session, and cannot be filmed before or after. The filming of, as previously stated in the decorum order and EMC, must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to where the bailiff is, where Jeff is standing over here. I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case. As such, we will take a brief recess to allow the relocation of the camera and to the place indicated by the bailiff, and then we will resume these court proceedings. I am anticipating this will take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate.
So anybody who knows how the court process works in these kinds of cases, especially high profile, the last thing they want to do for, in terms of a jury is to have a jury that is, impacted by, other people's opinions, whether that be news, media, what have you. The other things that the court's going to do is they're going to make sure that, even though everybody knows that he's incarcerated, right, they're going to make sure that he doesn't appear that way. So they're going to do their best to hide, any restraints, whether that be shackles, handcuffs, anything like that. From what I've seen in the video, it looks like he's not wearing handcuffs, but they do have him in shackles, as you can hear they're talking about. And he is appearing in plain clothes, so he's not in jailhouse attire. So that's to help the jury be impartial to his case so that they can have what they call a fair trial.
All right. Let's go ahead and address the state's motion to amend or clarify the publicity order. And I'll hear from all parties. And I know it has been briefed, but in responses, but I'll hear brief argument, and then we can go from there. Mr. Ballard.
Hey, have you subscribed to the channel yet? I think you should prove it in a court of law. Is there evidence supporting that you like the video? I don't know. Maybe you should just stop, pause, since you're this far in the video, and just quickly do it. It's the easiest way to support the channel.
Thank you, Your Honor. With respect to this motion, I think as we've expressed in the past, everyone in this room shares the same goal, and that is to ensure that there's a fair trial that happens in this case. And we recognize that the court's pretrial publicity order is intended to further that goal. And again, as I've stated before, the state plans to try this case once. The state is also committed to complying with its ethical duties with respect to pretrial publicity. We have complied with those duties. We will continue to comply with those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to reach beyond those ethical requirements and have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And the issue with the order that the state has is the use of the term witnesses in the order. We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it limited to just the prosecution team? And I think as we've expressed in our filings, we believe that the court intended that that term just be limited to the prosecution team, because that is the way that Rule 3.8 reads. Rule 3.8 of the Rules of Professional Conduct that deals specifically with requirements for prosecutors talks about investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor.
So as you heard, the hearing began with the court noting a violation of the decorum order regarding media coverage. Defense counsel, Ms. Visser, argued that live streaming had violated this order, potentially affecting Robinson's right to a fair trial by showing his shackles and capturing audio from the counsel table. This court hearing was roughly about an hour and a half long with all the bloat. So if they could move past the bloat, they'd probably get this done a lot faster. The defense requested remedial measures, including terminating media access for the day. So the media's response through the media attorney acknowledged the violation, but claimed it was inadvertent, that it wasn't intentional, that it happened by way of, just, it's not like they're pointing the camera at the shackles, right? They assured that measures would be taken to prevent future issues. The court decided to relocate cameras to avoid capturing the shackles or sensitive information, and warranted that further violations could lead to termination of media access. And then they did a pre-trial publicity order. The state sought clarification on the term witnesses in the court's pre-trial publicity order, arguing it was too vague. Okay, the court clarified that witnesses include anyone the prosecution or defense believes will testify, ensuring that attorneys must inform these individuals about the order's prohibitions. Okay, and then they did some stuff with victim representative designation. Okay, which is standard in these kinds of cases. The state requested the designation of Erica Kirk as the victim representative in the case. Both the defense and prosecution supported this designation. And then they handled their discovery stuff. The state actually provided an update on the discovery process, indicating that approximately 13,900 files had been received. Okay, with significant portions already disseminated to the defense team. The defense raised concerns about the sufficiency of discovery materials and requested that a preliminary hearing not be set until discovery is complete. Smart. And then they scheduled the next court hearing for December 29th and discussed potential dates for the preliminary hearing, ultimately aiming for May 18th to the 21st. So the hearing concluded with the court's recognition of Erica Kirk as the victim representative and plans to address the pretrial publicity order and preliminary hearing schedule in upcoming sessions. The court emphasized the importance of balancing fair trial rights with media access and public interest. Thank you so much for tuning in. I just wanted to give you a short video update on what's happening now.